I'm Scott Silliman, and it's my pleasure to welcome you to our conference this year. It's actually our 13th, and many of you who have been coming from year to year have been here for our prior ones. Every year we try to focus on some specific issue of national security law or policy. And this year we're going to be looking at whether the new administration, whoever that be, whether it be Democratic or Republican, whatever the new administration is, whether they will substantially revise or modify the current programs under the Bush administration for waging the war against terrorism, or whether they will follow a new path. In charting a course for a new administration, there are many different aspects of national power which have to be considered, all the way from the use of military force, such as in Afghanistan and Iraq, to acquiring intelligence, to even shaping foreign policy to ensure maximum protection against further terrorist attacks. As you can see from our program, over the next 2 days, we're going to be probing and analyzing and discussing many of the issues involved in an overall administration policy in combating terrorism. And I really invite you to join us in this discussion with your comments and questions. And in that vein, after each panel has spoken, we have tried to reserve at least 15 or 20 minutes for your questions and your comments, and we'll have a couple of microphones available for that purpose. Before we actually start our first panel, let me mention a few administrative things for you. All our panel discussions are going to be here in this auditorium, Janine Auditorium. For those of you who have signed up for the meals, both the 2 lunches and the dinner tonight, those will be over in the Thomas Center. And if you didn't come through the Thomas Center to get here, you go out the hallway to the end of the building, down the corridor, and across a little walkway, a covered walkway to the next building, and you go right into the Thomas Center dining area. That's where our 2 lunches will be in our dinner tonight, as well as the cocktail reception at 6:30 before the dinner featuring the Iraqi ambassador to the United States. For the attorneys present, we have received continuing legal education credit for 11.75 hours for this conference. And so if you would like or need continuing legal education credit for this course, then Balfour Smith or April Clark out at the registration desk would be more than happy to help you. You've been given a packet of materials when you came in, hopefully, and in that packet of materials there is an evaluation form. And I promise you, I look at those evaluation forms every year to try to improve our conferences based on what you tell us and your feedback. So please look at those, and as we go through panel to panel and meal speakers, give us your feedback as far as what you think of how we have structured this program and what we should do in the future. The 2 individuals at the registration desk, Balfour Smith and April Clark, are there for one single purpose, and that's to take care of any needs that you might have. So if there's anything we can do while you are here at our conference to facilitate your having an enjoyable time and a rewarding time, then please let us know, and we'll try to do that. I want to acknowledge the fact that we can't put on a free conference like this, unless we have financial support. And as you see in the program, we have been very, very fortunate to have some some organizations who provided administrative support. We've got the program in public law at the law school. We've got the Center for Comparative International Law. We've got the Terry Sanford Institute for Public Policy. We've got cyber right here at Fuqua. And we also have 2 individuals, Warren and Faye Wickersham, who have been very gracious in their financial support. I don't think they're here yet this morning, but where Warren and there they are, Warren and Faye sitting back there, and we're very, very pleased that they have been so supportive of us over the years. Again, if there's anything we can do while you were here with us for these 2 days to make your stay with us more productive, more enjoyable, please let us know. And without further ado, let me turn the podium over now to our first panel, and my colleague will be the chair, Professor Chris Schroeder. Chris?
Thanks, Scott. Let me add my welcome to you all this morning. Our first panel is on the topic of the role of private contractors in Iraq, Afghanistan, and elsewhere. It's a topic that's been much in the news over the last couple of years and increasingly the object of congressional interest on a variety of different issues. First, I think people being surprised at the number of private contractors when that information first hit the press that were playing essential roles in the mission in Iraq. Then some concerns about the behavior of some of the private contractors, concerns about the nature of the contracting process and whether that has been completely transparent and done in an appropriate way. And finally, some very complicated questions of what the legal liability is and the venues or the forums, legal forums, in which claims of improper conduct by contractors can actually be litigated and adjudicated. So there are a host of issues here to be looked at, and we have a very distinguished panel here that is going to take a run at a number of them and then be prepared to field your questions during the question and answer period after their presentations. The way we will proceed is that each of them will give some opening remarks for 6 to 8 minutes. We'll follow that by some interaction between and among the panelists in response to things that the different panelists have said, and then we'll open it up early to questions and comments from you all, so this can be as interactive as possible. I'm going to introduce each of the panelists to you now, so that I won't then interrupt the flow of the discussion once we get going. My role after this introduction will be only to, if necessary, pass to each of them a note that says 2 minutes left in their presentation. So I'll be the time police going forward. So in the order in which they'll speak, first we have Nadia Naviwala, who's a legislative staff member of Senator Jim Webb's of Virginia's staff. Senator Webb sits on the Armed Services and Foreign Relations Committees, and from those seats has been one of the most heavily involved U.S. senators in examining some of the contractor questions, and Nadia specializes in national security issues for the senator. She is incidentally, and I'm sure for her happily, on her way back to being a student for a while, as I see that she's going in the fall to the Harvard Kennedy School, and I'm sure she's looking forward to that, although also probably regretting that she's leaving the Hill, which is an exciting place to be. Next we have Scott Horton, who's a longtime human rights advocate, teaches at Columbia Law School, and is a national security and legal affairs contributor to Harper's Magazine. Scott's represented a number of individuals throughout his career who have been involved in human rights activism, such as Andrei Sakharov and Elena Bonner. He's been a vigorous and influential critic of many of the features of how the war on terror is being conducted. He's chaired some important committees for the New York City Bar Association on those topics, and he's also an expert on military justice and the international law of human rights and war. He's currently managing a contractors project for Human Rights First, and I saw from their website the other day that they have a very recent report posted on that website on private security contractors at war, ending the culture of impunity. And he's also, I understand, writing a book on the topic. Following Scott, we'll have David Hammond. David's a partner at the law firm of Crowell and Mooring in Washington, D.C., where his practice specializes in government procurement law and litigation. He's represented government contractors generally in a wide variety of settings, and he's also, in particular, been advising and representing private security contractors in that capacity. He's currently the chair of the Government and Legal Affairs Committee of the International Peace Operations Association, and he's lectured and talked widely on the topics that we'll be discussing today. And then we'll conclude something of a congressional sandwich here. We'll end with Steve Hedger, who's also a legislative staff member on Capitol Hill for Senator Claire McCaskill, who serves on the Armed Services Committee. And Steve specializes in military issues for the senator. Steve is a graduate, the 1999 graduate of West Point. After he graduated, he served in Kosovo and participated in the invasion of Baghdad in Iraq. Since he's returned and left active duty service at the rank of captain, he's maintained that rank in the District of Columbia Army National Guard, and he's continuing in a common tradition on Capitol Hill of earning his JD degree in the night program at Georgetown Law School while working full-time for Senator McCaskill. So that's our crew. It's a very distinguished group of people, and let me start off with Nadia, and let me invite you either to talk from where you're sitting or to stand at the podium, whichever you prefer. I think it should be live.
Good morning. My name is Nadia Naviwala. I work for Senator Jim Webb. What I'm going to try to do this morning is introduce you all, or actually these are issues that I'm sure a lot of you are familiar with, to some of the issues of accountability surrounding the use of private security contractors in Iraq that Congress has worked to address in the past year. And then tell you a little bit about what Congress has done and then how these changes are being reflected on the ground or starting to be reflected on the ground. To begin with, a lot of the questions, the basic questions surrounding contractors, and I'm going to focus a little bit more on the armed services side, is first of all, how many companies do we have out there? How many people do we have out there? And this is a very basic question that you couldn't answer a year ago. Who are these people? What nationalities are they? What type of work are they doing? Who are they working for? Are they directly contracted? Are they subcontracted? Are they working for other companies, other governments? How much are we paying them? How do you become a private security contractor? Every industry has standards, whether you want to be a lawyer, a doctor, anything. But what about being a private security contractor? Who's watching these people on the ground? How are we ensuring that they are complying with US, Iraqi, and international laws, as well as rules on the use of force? And then, what a major issue is how is their presence being coordinated with our combat mission in Iraq? To what extent are military and contractors coordinating when they're out on the battle space or in the battlefield? And then, of course, legal issues on criminal actions, on how you report, investigate, and prosecute incidents that occur. And most basically, should we be contracting security? To what extent? Who's deciding this, and how is it decided? And these were questions that when I started digging a year ago and found that there were no answers to, it was really alarming because they're just so basic. And what happened with Iraq is that we basically hired these people, sent them out there as a surge capacity, and then there was no really accountability or oversight for how to manage what they were doing. So into this mix, two things happened. First of all, Congress started acting with the last defense bill that was passed. It was in development in sort of the spring and summer of 2007, and then was finally enacted in January 2008. So while this bill was in development and in different stages of passage, you had the Blackwater shooting in September. And that put a lot of public pressure on DoD and on the Department of State to actually finally do something. And right after that shooting, you had Secretary Rice send a team over to Iraq and produce a report on diplomatic security, which generated recommendations, which they then committed to implement. And then you had the Department of Defense similarly say, we need to address these issues. So one of the first actions that happened was a Memorandum of Understanding in December 2007, where DoD and state came together and they finally said, we're going to address this issue and we're going to work together on it. We're going to coordinate our actions, develop similar standards, establish similar rules on the use of force. And they didn't lay out the steps, but they said, we're going to work together. We agree that there is a need for agreement, basically. And a lot of the elements of this Memorandum of Understanding and then subsequently what has happened there has been a reflection of the things that Congress has come up with. And some of the things that Congress has come up with I'll tell you a few of the major items. And if you want to look at it more closely, you can look at sections 861 to 863 of the Defense Authorization Bill, which was just, like I said, enacted in January 2008. Some of the most major things that have happened is that DoD has finally developed a system to register the individual contractors who are out in Iraq. Prior to this, you could have a person who commits a crime and then just gets recycled to another company because there was no record on what this person had done. Now finally there's a system called SPOT, which is incredibly detailed and requires, everything down to DNA and dental information on every individual that's out there. It's a great step forward, and the State Department and Defense are coordinating on implementing and registering all of their respective contractors into this system. So the numbers according to that we have now is that there are 32 companies working for DoD. Of this, there are about 9,952 private security contractors, and that includes subcontractors. And then about 6,500 are armed. And only probably, and someone can correct me on this one if I'm wrong, but I think about 2,000 of this 9,000 are probably American, or maybe less than 2,000. Now, the kind of flaw with this figure is that this is DoD's effort to register all the contractors, but there are just so many people out there. The estimates are actually between 20,000 and 50,000 on the number of contractors out there. So it's in development. It's an effort. It's started at least. And secondly, one of the major things is that prior to this, there were a lot of complaints from military commanders that they didn't know the contractors that were out there. If they needed to do an operation, they had no awareness of the number of contractors in their area of responsibility, or where these people were, or if someone was just moving through, if they could be moving into an area where the military was planning a mission, or it was just an unsafe area. So what's happened is, just in the past few months, the State Department and the Defense Department are actually cooperating on the ground. Prior to this, the most sort of coordination you had was for the U.S. Army Corps of Engineers with a operations center that was handled by Aegis. Instead, they've created an entity called CPOD that's at the multinational forces Iraq level, at the highest level, which coordinates security contractor oversight. And there's basically, DoD has a center called CONUC now. State Department has one called the TOC, and then there's a logistics movements. And between the three of these, if a contractor wants to move out, they have to submit it to basically this DoD or state entity and say, this is what I want to do, this is the number of people going, this is why we're going, this is what we're doing. And they have to get a response and approval before they go. And of course, it's supposed to be 24 hours, I think, before, but if it has to be short notice, that can work too. There's also a lot more logistical coordination on what's going on. And what I'm told is that they are actually communicating effectively, and this is a huge step forward. It's also very new. I think there's about 6 DoD centers like this called CONUC, and only 3 or 4 of them have been set up. Another huge step forward is that prior to the Defense Authorization Bill, private security contractors had no central location to go to if they wanted to know all the orders and regulations that applied to them. So what the Defense Authorization Bill said is that DoD needs to set up some central location, put together all these rules, and make them available to the contractors. So finally, DoD has actually done that, and I think it's helped a lot. And I think it's supposedly available online somewhere, although I couldn't find it last night. There's also, DoD has proposed rules on law of war training to ensure, because keep in mind, there's no training standards for private security contractors. So, Congress has made an effort to ensure that contractors are at least briefed on all of the rules that apply to them before they go out there. That's U.S. law, international law, Iraqi law, rules on the use of force, different guidance from commanders. So this type of training is now required in contracts for private security contractors. And there's also much more detailed standards on who can be a security contractor within these contracts that the government has with companies. And And there's also an established process now for the combatant commanders to bring issues to DoD. And this can include if they think that additional training is needed, such as cultural training, et cetera. So these are some of the efforts, and I mean, basically my point is that things have been very, very slow and alarmingly slow with Department of Defense and Department of State over the past few years. But in the past few months, a lot due to congressional action, a lot of efforts are in place and a lot of things are in movement and in flux. And a lot of this information isn't even easily available, and I think it will come out with the GAO report. GAO recently went out there and they're preparing something which will, I think, change the scene a lot. I think in 2 of the past years, the reports were called Actions Needed to Regulate the Use of Private Security Contractors, and the next one was Actions Still Needed to Regulate the Use of Private Security Contractors. I mean, literally, this was the title of the report. But the next one, I was surprised when I talked to them, and they were like, you know, our next report is going to be something like improvements have been made with the use of private security contractors, and some of these things are just really surprising because there was nothing like this a couple months ago. And a lot of that is because of the Blackwater incident as well and the public pressure that was generated to finally do something. So I'll just close on saying that a lot more oversight is needed and a lot more needs to be done. And we're gonna see what is happening right now and how it turns out. And something that Steve will talk a little bit more about is that our boss has worked on legislating a commission on wartime contracting, which is going to look at these issues over the course of 2 years, not just security contractors, but more broadly, and address some of the systemic issues that occur when we try to contract out our security. So that's all. Thank you.
Thanks, Nadia. Scott.
Thank you. I want to say, first of all, I had a case of our reports, which is called Private Security Contractors of War, shipped out here, so it's on the table outside. Probably not enough copies for everybody, but grab one when you're out there. And it contains a look at this entire issue from the legal policy perspective. So we have an analysis of the USA Patriot Act, the MEJA, and the Uniform Code of Military Justice with respect to their application, and a number of detailed recommendations for changes that should be made. And I'm not going to repeat anything that's in the report. It's just way too much territory. What I want to do is carry it a little bit forward, discuss a few things that have happened since our report came out, and I want to start with the issue of military justice. You know, it's a commonplace to say that military music is to music as military justice is to justice. And that may be true for some countries. I don't think it's true for the United States, actually. I mean, the U.S. Military justice system is something of a marvel. It's efficient, it's fair, and it's well adapted to difficult working circumstances, including dispensing justice in a field of combat at wartime. And so I start this with an attitude of admiration for this system and the people who operate it. And I was asked a little bit more than a year ago by Human Rights First to come on and help them put together a report, the same topic I was researching myself, and I said, fine. And I told them, well, I think we're going to have some tense discussions about one issue, because I'd spoken with Senator Graham and some of his staff about his efforts to change UCMJ. I had bought onto this idea. I really thought restoring UCMJ jurisdiction over contractors was a good idea that had a place, a role in this total sum. And of course, I know the human rights community, this is just axiomatic. I mean, there are no military tribunals for civilians. It's sort of a fundamental point the human rights community is locked into. Well, fortunately, I had a few allies in this process. General Krulak, General Hoare, Admiral Gunn, Admiral Hudson, who had all come on as advisors to this project and who also thinks pretty much the way I did. So in the end, we prevailed, and we have that recommendation here in the report. Well, we've had a pretty long gestation period on this, and on March 10, Secretary of Defense Gates put out a memorandum with attachments that begins to address, although it doesn't completely address all the questions, begins to address the questions of implementation of the amendment to Article 2 of the UCMJ that provides for court-martial authority with respect to civilian contractors. And I want to talk a little bit about that, and also about the first potential test case we see coming down about it. These are all things in the headlines right now. Just my viewpoint up front, I have to say, I'm a big fan of Secretary Gates generally, but I have to say, I think he gets everything right in this memo, and the Office of Secretary of Defense does. I think it sets the right tone, it sets the right rules, the right threshold mechanism, and so forth. In fact, I read it through 3 times thinking, surely I can find something to criticize. But in fact, no, I can't really find anything to criticize. I think it's right on the money on every single major issue. And I think most importantly, first, it starts with recognition that court-martial is and should be the exceptional case. That is, by and large, the response to a contractor seriously misbehaving in the field should be put them on the transport back to the United States and let the Justice Department deal with it. You know, that's pretty clearly the default position that should exist. And the memorandum, you know, recognizes that by providing an initial period for DOJ review and action. It also sets the right criteria for the exercise of court-martial authority, and there are 2 major categories set out here. One essentially is, does the conduct that's the subject of the complaint affect a vital military interest? Now that's sort of vaguely put, but I think that's put in more or less the right terms. That is, you know, it has to be something that really is of concern to the Pentagon and to the commander out in the field. And the other is, does the jurisdictional reach of the United States otherwise fail to cover this situation? That is to say, we really don't want a jurisdictional vacuum. And the jurisdictional reach of the UCMJ, in theory at least, is broader in many respects than the other statutes we have. I mean, the USA Patriot Act in conjunction with the Special Maritime and Territorial Jurisdiction, or the MEJA statute. So it's good to have that there as a safety net that can be applied if, in the end of the day, nothing else really works. I think he's also exercising a reasonable degree of prudence in saying that the court-martial authority should be exercised at a very high level. So he's reserving that for the Office of Secretary of Defense and for the regional commands. And I think, given the importance of policy issues that are going to come up, particularly at the outset, this is significant. So obviously, the exercise of this court-martial authority is going to raise a number of very sticky legal problems. You know, we haven't had a court-martial case involving a civilian since 1968, I think. You know, it was just accepted wisdom that you couldn't do this because it was unconstitutional as a result of a number of higher court rulings, certainly one in the Supreme Court itself. You know, and we have a fairly detailed analysis of this question in our report, but my sense is that in the right case, at least, these constitutional roadblocks will now be overcome. And I think there are 2 particular reasons for that. One is that, of course, those decisions came down in the heyday of the Earl Warren Court at a time when concerns about procedural constitutional protections were at their zenith. There's been, I think, quite a bit of reassessment and retrenchment of those viewpoints. But actually, much more important than that, if you look at the transformation of the court-martial system itself between the early 1960s and today, you'll see a pretty dramatic shift, and you see the shift occurring with respect to these same issues of constitutional civil liberties. Now I want to come to to what may be a test case, an interesting case, in any event something to keep our eyes on. On March 27th, out in Iraq and the Radwamiya Palace complex, there was a brawl involving the brandishing of knives. And a Canadian-Iraqi contractor named Ala Muhammad Ali stabbed another contractor. These were both interpreters. And the assailant was apprehended and is now being held pending charges. And I posted a copy of the charge sheet. You can find it by surfing the web. It's interesting, though as it stands right now, we see only the first half of the charge sheet has been filled out, which was necessary to justify the detention of the contractor. The second half, with the actual preferred charges, has not been filled out. Nevertheless, this is a significant development, a significant case, and we may very well see the first test case of the Gates Memorandum and the amendment of Article 2 develop out of it. Thank you.
Thanks, Scott. We obviously have our headline already of the conference. Author of Human Rights First report says Secretary of Defense has it exactly right. Not something that they're used to down there at the Pentagon, but I'm sure we'll appreciate it. David.
Thank you. I guess if this is a legislative sandwich, I hope I'm not sausage in the middle. But first I'd like to thank Duke and Center for holding this conference on a very important and timely topic. Also, just to give a caveat that the views I express today are my own and not of my law firm or any clients or any organization that I'm affiliated with. To start off, I think we can agree on the premise, and that is that contractors are needed today when our nation goes to war. This is not new. I think in World War II there were 700,000 contractors. In Vietnam there were 80,000 contractors. In the Balkans operations in the 90s there were actually more contractors than there were military forces. Certainly there are issues that go along with this, and they're important issues that need to be addressed and resolved. But to put some of this in perspective, and today and what is happening in Iraq, the numbers out there range from, say, 180,000 contractors maybe at the peak, but out of that, I think it was the GAO that determined is about 118,000 of that were Iraqi locals. So there's not a lot of American or foreign contractors running around there. Number of security contractors is actually a small fraction of that, maybe a total of 6,000. But again, a large portion of those are Iraqi locals doing static security. For the Department of State, there's about 1,400 contractors, security contractors, protecting the diplomats. And out of that, about less than 1,000 of those are actually U.S. citizens. So the number of security contractors is certainly disproportionate to the attention that they get. But then again, they are performing some very difficult jobs in difficult circumstances, and there have been incidents that have drawn attention to them. Certainly in terms of oversight, contractors in general and security contractors in particular welcome oversight. There's no objection to it at all. The industry is out there cooperating with the legislators on trying to establish more oversight and to plug some of the gaps in the legal framework. But to say that there's no oversight, I think, is an exaggeration. There is oversight. Can it be improved? Yes. But there is oversight. You have the contracting officers, you have agency personnel, agency inspector generals, you have U.S. attorneys, you have congressional hearings, you have the GAO that looks at these issues. There have been prosecutions. I think I looked at the Special Inspector General report for Iraq. In his January report, I think he listed about 10 or 12 of contractors that have been prosecuted and have been convicted. Now, a lot of those are what you would call economic crimes in terms of fraud, where I think a lot of focus is more on, at least on the security contractors, on other type of crimes or alleged crimes. So the industry is fully supportive of filling these gaps. I think we've heard some of them in terms of the Uniform Code of Military Justice and some of the gaps there and how that applies. The Military Extraterritorial Jurisdiction Act is another one that can reach, but it has limitations also that need to be addressed. And certainly, in terms of looking at the different mechanisms out there, the Uniform Code of Military Justice, I think, is certainly one. I would offer that I think a better one is to make sure that there is civilian jurisdiction over the contractors, and to certainly have that as the first option, which I think is actually the memo that Scott mentioned from the Secretary of Defense makes clear, as well as a memorandum of agreement, that the first preference is civilian rule, and that only when there is a gap there or there's not an effort by the civilian authorities to take jurisdiction will the military jump in. And I think that's the right approach, but we have to make sure that the laws are there to provide jurisdiction over contractor personnel. So there has been a lot of progress. I think we've heard some of that. The Memorandum of Agreement, I think, it was a very good step. I agree that Secretary Gates' memo has it right in terms of the approach and the process that they're trying to outline. I think that's important. Of course, you have to see the implementation of that, and the devil is always in the details of the implementation. There are some practical issues, though, even if you have the right process. Practical issues is how do you investigate an alleged crime in a war zone? I think it's a real issue of trying to get the right personnel there, the right funding, and how do you go into, after an incident has occurred, how do you go there with the right people with the right skills to investigate the scene when you're in an environment where often something happens and they wait for people to come to assist, or in this case would be investigate, and then attack them. So it's a very challenging environment. For the people who would be subject to the prosecution, to make sure that all of our civilian standards apply, full rights and due process for those people, and make sure that it's based on facts and evidence and not reports in newspapers. One of the issues that is often raised, and I think it's one that will receive congressional attention, is whether security contractors are performing an inherently governmental function. I think it's an issue that needs to be debated, but I think there is a conclusion to that. And indeed, as I'll mention, there already has been a conclusion to it. But first, what is an inherently governmental function? The federal acquisition regulations, which are the regulations that govern government procurement, define an inherently governmental function as follows: a function that is so intimately related to the public interest as to mandate performance by government employees. Well, that's pretty broad. How do you define that? In fact, it's so broad it goes on to recognize this as this definition is a policy determination, not a legal determination. But they include things that require an exercise of discretion in applying government authority and in making value judgments. But recently, in connection with promulgating a contract clause, the Defense Acquisition Regulation Council, the body that issues these regulations, looked at this issue and concluded that private security functions are not inherently governmental. Indeed, they hire security guards all the time for protection of persons and property. It may be guarding a base either domestically or abroad, and that's not an inherently governmental function. The also issues of whether private security engage in offensive operations keeps on coming up. They do not. It's a strictly defensive operation only. There's an inherent right of self-defense, and that's what they do. They respond when they are attacked. There are lots of challenges out there. We'll get into some of those in terms of compliance. For industry, the issue of third-party liability is a significant issue in terms of the plaintiff lawyers handing out cards on the battlefield. That's not a place where I think we want to go. And then also I think we need to look at the issues of the acquisition workforce. There's two sides of the equation here to make sure that the agencies have the right people in the right place at the right time to properly structure and manage their contracts and contractors. I think with that I'll end. Thank you.
Thank you, David. Steve.
I think I can build off, well, first, thank you for this conversation. I actually wanted to start with sort of a reality comment, which is the timing and the topic of this conference that Duke has chosen, regardless of the fact that over its history it's always been national security, couldn't be more timely. And folks like Senator McCaskill and Senator Webb and we at the staff level are dedicating enormous time and resources to the questions that will be discussed over the next 2 days here. And so it's a privilege and I think a great opportunity for Nadia and I to bring back some of the institutional knowledge of folks, industry perspectives, academic perspectives, practitioners' perspectives, and elsewhere, because in terms of shaping where this will go for the next administration, we are at a crossroads. We have perhaps started down that road with some of what Nadia talked about, but there's much to be done to improve the overall system for the future. I thought funny that David said he's afraid of being the sausage in the middle, which made me think about the lawmaking process, and I'll try to avoid a Bushism, but the cliche is something like lawmaking is like sausage. You don't want to watch the process, but the end product sometimes is pretty good. In some ways, I think we have had that result in the last year or so, particularly with the new leadership in Congress. The ugly process, in many ways, has been the oversight process in the public hearings, which has certainly been painful to industry in some ways and to the administration in some ways. We've had a series of much publicized, high-profile hearings that some would wonder what really comes of them, and at what cost and to what benefit. But I would submit that in addition to being responsive to what the public wants to see their Congress doing, the conversations and types of work they want to see them doing, that when you finish unpeeling the onion and get away from some of the cameras and the sensationalism, that there is the meat and potatoes work going on at the member level and at the staff and professional staff level to take those hearings and the issues that are discussed and turn them into reasonable, practical lawmaking and statutes. And that is Section 862, as Nadia talked about, on private security contractors. That is the application of UCMJ, where we have gaps in jurisdiction over accountability of contractors in foreign operations and otherwise. But there's also a reality that we have only begun down that road and that Congress has in some ways piecemealed the process, patchwork fixes. And this is an area that Senator McCaskill and Senator Webb particularly looked at when they came in. Both campaigned, both freshman senators campaigned that they were going to come to Congress and make a keynote issue for them fighting fraud, waste, and abuse in Iraq. Having lived through the first year and watching both of them, they both wanted to create a Truman Committee of World War II type proportions, which they would lead with their colleagues, and it would be a congressional committee led by them to look at and investigate fraud, waste, and abuse. They ran into one problem, or more than one, but the biggest one was when we showed them the time and resources that then Senator Truman dedicated, they said, I don't have those. There are political realities to the challenges of their jobs, the number of issues they cover, the number of requirements placed on them to do that sort of committee. And that applies to House and Senate members. And so we looked for how do we get at a broader investigatory process, and how do we look in more depth at these issues. And also, how do we escape the partisanship of congressional oversight on these issues today, which is a very destructive force in terms of the ability to write a law. When you get everyone at odds and everything is not a substantive policy question, but a question of witch hunt versus protecting the administration or otherwise. Extremely destructive atmosphere for passing good substantive policy. And the solution that Senators Webb and Senator McCaskill went after was for lack of a better word, outsourcing some of the work, creating a partner organization, in this case a congressional commission, to get at the detailed substantive issues, to put experts on such a panel who have the backgrounds, academic, industry, investigatory, in contracting issues, who will have the time. They aren't going to 3 or 4 different committee hearings, being responsive to constituents across a number of issues, to look at these issues. And that is the nexus of the Wartime Contracting Commission, which we think is and should be one of the most critical looks at the issues of contracting, from private security contractors to logistics acquisition issues, to what is inherently governmental, all the questions that Nadia sort of mentioned as she was speaking. And so there'll be a commission. It was a hell of an effort, but we got past the partisanship and we got it passed. And there'll be an 8-member bipartisan commission with a 2-year term of existence. We are in the process of picking the commissioners now. We think it will be a principled, nonpartisan, non-witch hunt type effort. We think it's absolutely vital that it is. And that will help the Congress steer and the new administration the right path or take the right course in the future on these issues. So some patchwork fixes in the sausage-making process so far, with some frustrations of what we ought to expect, which is highly political, publicized hearings in the middle, and then a commission to help the Congress and the new administration in the days ahead to steer the course and get this right in a comprehensive broad look. So I think that's a very important thing to think about. The second is, and David hit on this point also when he talked about the acquisition workforce, we are very good in Congress at sitting at a panel such as this and looking down at witnesses, many times contractors themselves, and sort of lecturing them as to where they have gone wrong. We are not as good at looking back at ourselves or our own institutions, and sometimes those of the administration of which we provide oversight to. Politicians are very good at it. Couldn't possibly have been us. But the irony of some of what happens at these hearings, and it's not reported in the news this way, you hear the clip of the congressman or the senator lecturing. What you don't hear is the witness often responding, but the law permits this. The law, we have done nothing illegal in this process, and I think the first thing that comes to my mind right now is KBR having an offshore office in the Cayman Islands, which enables them to assign all of their contractors to that office and avoid unemployment taxes, Social Security taxes, and otherwise. It's offensive. Those folks who come back, those employees after a tour in Iraq, cannot get unemployment when they come back and are looking for work. But it's legal. So the fault is somewhat our own. Beyond that, the acquisition workforce, whether it be those who are writing the contracts or those overseeing them at the audit level, has terribly failed us. And they have failed us in part because the Congress made them smaller through the peace dividend in the Clinton years, quite frankly, and making government smaller. And we have also under-resourced them. If you looked at, there's a great chart of the Department of Defense Inspector General's budget. Their budget has stayed flatline while our expenditures on contracts has shot through the roof. There's a basic and obvious delta there. They do not have the resources, the people, or the structure to respond to the mission they've been given. And so what we created was a vacuum in which the contractors, not surprisingly, as money-making enterprises, like a children would if they got away from their parent, they're stretching it to the limit. If someone is not looking, they're going to find mischief, perhaps legal mischief, perhaps illegal, but probably more legal. And so there's a real challenge ahead of how do we structure, how do we look at our oversight force in agencies, whether the contracting officers who are writing contracts or those who are auditing and overseeing them through the process, to have a system that reins in the children a little bit. And that is really absolutely critical that we resolve how to do that in the years ahead, because without a structure, without some supervision to match our laws, there will be mischief. And we have, I'm not going to go into it, but we have undertaken some actions. The Congress is acting to grow the acquisition workforce. We are getting DODIG on the ground in Iraq. We are adjusting how undefinitized contracts can be written and otherwise. But the challenge remains to get to adult supervision, because adult supervision, for lack of a better term, and that's a little bit condescending, but is vital to having structure in theater to keep things to keep there from being mischief. I think we're going to end up talking more about UCMJ and MEJA. I just want to make one comment on it. Everyone is in agreement that it's better when there is criminal activities on behalf of a contractor in a war zone, that it is better for that criminal activity to be prosecuted in our regular criminal system, through the Department of Justice and otherwise. But a certain reality played out over the course of the war, which is it wasn't happening. There are many reasons why it wasn't happening, but it wasn't happening. That inability to prosecute American wrongdoers' regular criminal activity in a foreign theater in Iraq can erode very quickly how the Iraqis view us. There appears to be double standards. There appears to be protectionism of our folks, and that erodes public support, which in a insurgency-type warfare erodes our ability to win the wars. But to the extent that we haven't been able to get prosecutions under MEJA, the Congress was left to fall back on something. Scott was mentioning how good the military is at this. And essentially, the Congress, the response, in addition to the jurisdictional gaps, looked to where can we get some actual prosecutions. We have got to get the law being applied. We have to get accountability. And they turn to, as we do in so many instances, the military. And so therein lies more specifically pushing to have the UCMJ apply, because it's sort of like a nation building. Not a great job for the military, but only they really can do it. We turn to them. And in this case, prosecuting criminal activity of U.S. contractors in a foreign theater, it should happen under MEJA. There's some basic things to address, but it wasn't. And so Congress and the American people, I think, have turned to the military again and asked them to step in and find a way to do it. But it raises many, I think, important legal questions. So with that, I'll wrap my comments and we can have some discussion.
Great. Thank you all very much. Let me ask you, before getting each of your reactions to anything else that the others have said, about a question that I think we haven't touched on so far, and that's the basic policy judgment about what the right mix is between military and private responsibility in country. Because I've read criticisms of the current high levels of private contracting, that they can create problems for the overall success of the mission, because contractors don't sit in the chain of command. You can't redeploy outside of the contract terms. The contractors are not directly responsible to the military commanders, and there's at least been speculation that the interaction between the military and the private contracting security forces sometimes gets in the way of operational success. So, and I don't know whether that's true or not. Whether you read anecdotes and you hear speculation. The question I wanted to ask you all is whether, in your judgment from Congress's perspective, that basic decision about what the mix of deployment is ought to remain essentially a DOD, DOS executive decision-making function, or if you might anticipate Congress having some say in general guidelines or principles that might implicate how you answer that question. Yeah.
I'm happy to take that on first. I'd say just as a preliminary matter, I'd like to talk about how this question affects the accountability model. I think one problem we have right now is that we crafted an accountability model that was geared to a different kind of force with a different kind of footprint from the one that's actually been engaged and used in Iraq today, which is to say the ratio of uniformed military personnel to contractors is quite different from historical models. I mean, David talks about the Balkans. I usually don't deal with that. But if we look at traditional conflicts, World War II, Vietnam, it's quite radically reshaped. And if we look on the military side, the accountability system seems to be working normally. We have, given the number of people, the duration of the conflict, roughly the number of court-martials you would expect, and also a proportionate number of non-judicial punishments. It's just on the contractor side we just see a follow-through, and that's because there was no adjustment to the accountability model to take into account that we had this different configuration. So I think that's one very important point to keep in mind. The second point I would make is I agree with David on this point. It would be very dangerous for Congress to become too absolutist about this, for Congress to step in and say, oh, these are inherently governmental functions, and therefore we can't have contractors in all of these different areas. That would dangerously impair the latitude that policymakers and people in the Pentagon need to have dealing with the pinch situation, where you very urgently need to do something, you don't have the forces to do it. They need to have latitude to act in those situations. That being said, I think that there are very important policy issues here that go more to the broad force configuration idea that really haven't occurred. I mean, we had this fixed sort of by virtue of default. And I think the country is way past due for a serious discussion about the force configuration and whether what we have right now makes sense. I've discussed this with 2 of the 3 presidential campaigns. I have a sense that we're probably steering towards that sometime early in 2009, and I think that'll be a very healthy thing.
Go ahead, Steve.
I think that the debate on, essentially this is a debate on force mix. What should our standing military have as far as their forces, and what capabilities should they have embedded? And when you get to that debate on force mix, it's impossible to divorce that discussion from the costs of a standing military and the realities of an all-volunteer force. There is no doubt that we had a swing under Secretary Rumsfeld to reduce the number of logistics forces and outsource functions that he thought was to some extent fat on the body of the military, and to take our active duty military and reserves, have a little bit more of a lean force, but more focus on our combat capabilities, with the ability to augment them in times of war with a contracting logistics force. And that is sort of how we got down to the road where we are now. Part of that is, there's 2 things that drive that. One is it's very, very expensive to maintain an active force. It is paying for those people and keeping them in the force over time, particularly in times of peace, is very expensive. So you have a cost-benefit analysis, an economic analysis of when do we, or what expectations do we have for how much we will deploy and be in conflict, and is it cheaper to have these perhaps non-inherently governmental, cooking, food, driving trucks, or otherwise tasks given to private contractors, even at a fairly high price over a short duration? Is it cheaper to outsource those tasks than to maintain a force permanently? And the second part of that is the ability to maintain the force, to actually man the force. It is widely publicized, the challenges that we have to recruit right now to maintain the all-volunteer force. There have been some Democrats on the House side who have talked about the need for a draft. And in part, they are not, I think, seriously talking about a draft, but they're making a political point that this burden is being shared by a very small number of people. And the military, in many ways, has resisted growing too large, both because of cost and because they can't recruit and then maintain the type of quality all-volunteer force that we would like to have as the world superpower. So I think those issues you can't divorce from this conversation. I think the most important thing is, and David made this point, contractors are going to be with us into the future. It is something my boss has to some extent admitted. There are those who are fighting. They want to pull tasks back, put them back into the military. There's limited reality to that happening. Contractors will be a part of our expeditionary operations well into the future. But the issues that I talked about in the second part of having structure, both legal and regulatory, functional, well-written, contracts, and then a robust, present oversight force to manage those contracts where they're being executed is what will make it successful. Our biggest failures are in writing those contracts and then overseeing them and having the people to do it, not necessarily in having contractors on the battlefield.
Yeah, I'll just make a few quick points. The question that you asked brings up two things. First of all, like they've mentioned, the force structure, and there is a move. GAO has recommended this, and I think there's some favor in DoD towards when DoD submits its budget to Congress and creates a force structure projection, that it include the number of contractors that they think are going to be a part of that, because increasingly with our operations, contractors are going to be a part of our force structure, and we need to start accounting for not just how many military and civilians we have, but how many contractors as well. And that is probably an area where Congress can take action on. And secondly is the question of inherently governmental functions, and that's a very debated and very complex question, and one of the issues that the Commission is going to spend 2 years studying. So those are two issues. In terms of coordination with the military, and this has been a big problem, which I think is part of what's starting to be addressed, is that first of all, GAO has also recommended, and it has started being implemented, a training package for military before they deploy on how to work with contractors in terms of what they can tell them to do, and that type of thing, what to expect when they get out there. And secondly, in terms of the contractor movements, like I said before, the system was voluntary for contractors to report where they were going or what they were doing. I mean, participation was completely voluntary. Now it's mandatory, and all of the centers are communicating between DoD, between state, and with the Iraqi government, and a response is required, permission is required in order for a contractor to move. So, DoD can say, no, you can't move, and there has to be full situational awareness, and there is a move towards that. And I think there's also a move towards bringing contractors under the combatant commands, and at least DoD is required to issue guidance to the combatant commanders on how to issue, how to tell contractors what to do, basically. I think there's a move towards requiring that, but the problem is going to be, what if they don't? If a contractor says no, then you get into the legal issues of what are the recourses there. So those are just a few of the issues I think.
Well, the DoD quadrennial review has already stated that contractors are part of the total force. They consider them a force multiplier. But there's an important point, I think, that is often overlooked, and that is, what is the mission of our military? Traditionally, it has been one of two things, offensive and defensive. Our military has now acknowledged that there is a third role out there that they've accepted, and that is reconstruction. Call it nation building, call it whatever you want, but they've acknowledged now that that is a third part of the mission, and that usually involves contractors. A lot of the contractors over in Iraq are part of that reconstruction effort. And then again, if you have contractors doing that, and I think it makes sense to have contractors doing that instead of the government, you need to provide then, of course, a secure environment. And that also involves protecting people when necessary to go and do that important work.
I want to, David makes an interesting point about sort of the expanding mission of the military, which I think has been an interesting debate, particularly within the uniformed services themselves, of how they conceive of their profession and what missions they have. General MacArthur's comment, famous quote is, the mission of the military is to fight and win our nation's wars. Well, the critical question then becomes, what does wars mean? And the military as a profession in the post-Vietnam era managed to define war into a very narrow sphere, and that was offensive and defensive operations. And in part, we didn't have a post-conflict, post-offensive operations plan in Iraq because the military didn't want to do it. General William Wallace, who was the commander of 5th Corps of the Army, so one of the two most senior-most ground commanders, was asked after he came back at the beginning of the war, said, someone asked him, why didn't you have a plan for post-conflict? And he said, nobody asked us to do it, and we didn't want to. Well, that, to me, is a fundamental failure for the uniformed services, for our profession that has the expertise in violence and the application of force and to serve our interests in winning our wars. They're kind of coming around to realizing that there's something new. But there's a second aspect to that conception of what they do, and that is what is the uniformed non-acquisition personnel's role in overseeing the overall role of contractors. If contractors are in essence a part of their command structure now, of their team, they have to have some competence in who they are, what those contractors are doing, what control they can have over them, and then how to oversee it. And for essentially the first 3 or 4 years of the war, the same sort of limiting definition by our senior military leaders hurt us. They said, we control our military folks, and the contractors, they're on their own. They're not my responsibility. I ask them to do things, but it's not my job to oversee them or make sure they're not wasting money, or that I'm asking them to do things that are exorbitantly expensive. And there is a sea change happening in the military, which will significantly help us better manage this contractor situation, which is that our command structure in the military, our senior uniformed leaders who are commanding over there, who are not acquisition personnel, are realizing the importance of their management and command role in controlling, overseeing, and managing contractors. And they're also realizing that the American people will not support their expeditionary efforts. The American people are a friendly center of gravity. You need them to be able to conduct expeditionary operations and to win your wars. And when the military fails to be a good steward of the American taxpayer dollar, and that center of gravity loses confidence that the military operations are no longer being good stewards of the American dollar, you lose the ability to operate. And so, in some ways, public opinion on this war has changed because of fraud, waste, and abuse. That limits our military's ability to achieve victory. And so they realize they have to make this a part of their professional responsibilities to oversee, manage, and control the contracting spectrum in their area of operations.
Okay, well, I'll serve notice to the people with the microphones, as well as the audience, that we're about to go to discussion from the floor, but let me give each of you, if you care to use it, you're free to yield your time, but if you want to take a couple minutes to respond, either by way of agreement or disagreement to anything that your panelists have said, we'll do that first, and then we'll go to the floor. So, Scott,
I'm perfectly happy to yield my time to the floor.
Right. David?
I guess I'd just respond to a comment of reference to the contractors as children. I think that probably is a little over the
It was
top.
rhetorical.
I understand. But there's some interesting irony, though, on the Wartime Contracting Commission, that it recognized that it didn't have the manpower or the time to do an oversight job, and so they're outsourcing the outsourcing of oversight. So I think it's an interesting parallel there, that because it's exactly the same position the military found themselves in. And it's also somewhat interesting, as if I can, that the Congress, who is looking at this, it'd be interesting to take and look and see what, in terms of percentage of the members that have been subject to an investigation, indictment, or conviction, as a percentage of that population compared to the percentage of the contractors. I speculate you may find it be higher in Congress. So I think that's something to look at. In terms of, to put some sort of ground truth on how the private security contractors work, they don't go to the Department of State and say, here's what we're going to do and here's how we're going to move. It's actually more the opposite. It's the Department of State personnel who say, here are the missions that you're going to perform, here's what we need to do, and then often here's the route that we want you to take. There's some give and take on that. But there's a very high degree of operational control over the missions that occur there. And indeed, since Secretary Rice's, some of the changes she's made, she's putting an agent in charge in every convoy that moves. So that's a Department of State person. So the contractors aren't out there just operating free on their own. There's a large degree of oversight on them.
I'll try to be very brief in this. One, in fairness to David in the Blackwater, and I was telling him this story last night, in the Senator's first year in office, she and I went to Iraq, and I had told her before we left, having been there, that her conception of private security contractors was about to change. And it changed because we had, during our 48 hours in theater, a team of Blackwater contractors that provided her security. And they were absolutely professional, well-trained, respectful folks. And she recognized that these are not just cowboys, for better or for worse what there is in the media, but there are still real conversations. And the issue is, David pointed out how small a part of the contracting force they make up. But if you do the risk analysis, if you think about a chart and you put risk on one side and you put resources and time that you need to dedicate to their oversight on the other, because of the level of risk of an incident with an armed contractor, you need more resources and oversight. They're going to get more attention. And the reality is that an incident such as what happened in Baghdad can be with the shootings, can be a major influencer in how we are perceived in the public, and therefore our ability in the security and safety of our troops, and to have a positive solution. So they are, I think, skilled professionals, but because of the nature of what they're doing, and if they keep doing it, if we don't consider it inherently governmental, they warrant more rules, more oversight, more attention. That comes with carrying a weapon and having that sort of ability to influence the overall course of a conflict.
And I don't disagree with that. We welcome the oversight, more accountability. Whatever the rules are, the companies will operate under them. I think the reforms that have happened, the changes that have happened, are bearing some fruit. I think since the September 16th incident for that particular company, they've conducted many missions, and only out of that 3 have resulted in an escalation of force. So I think putting an agent in charge there, putting cameras in these vehicles, which is actually something the company had been asking for prior to that happening, are good things, and I think it's showing that showing some results. I think it would be interesting, though, to look and say, is the incidence of fraud, waste, and abuse with contractors in Iraq any larger than the fraud, waste, and abuse in contractors not in Iraq? I would suspect you may not see much of a difference.
I'm just going to make a few points. In terms of outsourcing this oversight function to the Commission, the difference between outsourcing security and outsourcing oversight is that we're not outsourcing to the private sector. We're outsourcing to specialists and academics who can actually spend time studying this issue. It's an incredibly specialized topic, and there are very few people, I could probably count them on one hand, who are working on this issue in Congress. And there is a sort of wariness towards legislating specifically, as Scott sort of warned, specifically and absolutely what they should be doing on the ground in Iraq, because it's really hard to know what's going on the ground in Iraq. So even the legislation has said, DOD, figure this out and take into consideration X, not DOD do this. And that's why a lot of these things are in development, and we kind of have to see what's going to happen. But at the same time, there is that need for a more specialized oversight, and that's why the Commission is going to be there. And then to respond to a few of the points that David made when he was speaking, in terms of it's true. I mean, PSCs are not a new phenomenon. We've done this before. But the real issue here is the extent of our reliance and the lack of accountability. I mean, the lack of what we know about these guys is just not up to par with what should be expected from the U.S. government and from the military when we have people carrying guns in a combat zone. It's true, what he said, okay, there are only 6,000 contractors in Iraq. But like I said, these numbers are most likely underreported. I mean, it's probably actually between 20 and 50,000, not 6,000. I mean, it's a new system. They've just started registering people. So those numbers are underreported. And then, I mean, you have figures out there, for example, between, I think, 2004, 2008, DOD has said there were only 151 weapons discharges. Okay, that shocks me as being very low. And, I mean, that's under a voluntary system of reporting. I mean, if a security contractor is involved in a shooting or, discharges his weapon, the onus is on him, and it's voluntary for him to have reported it. And now, now hopefully that system is changing. So, and I mean, I think there's a tendency, and I'm not going to put the blame on the private security contractors for this, because I think the blame or the fault is largely with the government, with DOD, with the Department of State for not taking up this question and providing the rules for more aggressive oversight. And like David said, and I've worked with the industry as well before, but they are very welcoming of increasing regulation and oversight on this problem because it helps them do their job better and not constantly come under fire. So that's about it. But I mean, the PSCs have done a good job. Steve's told me before when his boss went out there, she was very aggressive about PSCs, and I think a lot of other people are surprised because when our bosses go out there, they're protected by private security contractors, and they do a good job, and they do suffer high casualties. So by no means, are we trying to always come down hard on them. I think a lot of the responsibility is also with the government.
Let me just say it in terms of voluntary reporting, at least for the State Department contracts, which I think are very good contracts, are probably a model of how you want to do them. It's not voluntary. If there is a discharge of a weapon, you fill out a report. That is required by the contract. And if it is missed, then there's enough oversight there that these things come out, and you will suffer the consequences if you try to cover something up. So these reports are there. In fact, there are quite a few of those reports because they've all been turned over to some of the congressional committees. So I think there is a level of oversight there just through the contract. And I guess one other point is with private security contractors, most of them are former military. These are our sons and daughters that were trained by our military. They've been in that situation before. Some of them have been through tours at Iraq. And they don't change their character when they walk across the street and start working for the private sector. They're the same people, and they're not out there all of a sudden spraying bullets, which is often the public perception.
Just a quick counterpoint. The diplomatic security, it's true, does have or has had more stringent standards of reporting, and I'm sure under theirs, if it's diplomatic security, that it was required for them to report it. But those contractors are a much smaller proportion to the DoD's contractors, the convoy security, the static security probably, but also all the subcontractors that work on reconstruction projects under USAID perhaps. So, I mean, it's true that the worldwide protective services and diplomatic security had more stringent standards, but a lot of the other contracts haven't required it.
All right, let's go to the floor. Wait just a second and we'll get your microphone.
I'm John Brooks from Raleigh, and my question is for Mr. Hammond. Do our federal contracts with private employers require the private employers to provide their employees benefits at least equal to what they would have received if they were federal employees? And if not, why not?
I don't think there is a requirement. I think of course, there's a wide range of different contracts out there, and certain contractors will provide certain benefits and others will provide other ones. The way our procurement works, though, is based on competition. And if there are some companies who recognize that the competitive nature is such that they may not be able to offer those benefits. For some in this private security contractors, they use an independent contractor model where they pay the person a high rate, but that doesn't cover any of the benefits. So the person would otherwise pay for those benefits. But there have been some studies done in terms of economic analysis and looking at what they receive and the tax burden on those people, and then what also the government receives, the person that would otherwise do that job, and you add in all their benefits, and it comes out roughly the same.
Corner here.
I'm Rear Admiral Dusty Miller, former JAG of the Navy, and as one who has spent his entire life administering the military justice system, I heartily agree with the panel's conclusion, I think, that the military justice system is a good system and can be used. But it's in that context that I have the following questions. How confident is the panel that Senator Graham's amendment will be held constitutional? Secondly, I believe that everyone in this room would agree that the civilian system is preferable when a civilian commits a crime over the UCMJ. But I'm wondering what you think if that civilian system was not the American system, but the Iraqi system.
Well, I think first on the first one, I think there are significant doubt on whether you can prosecute a civilian under the Uniform Code of Military Justice for a felony. I think recent, not so recent, but case law has developed on that in the Supreme Court that calls that into question. I think that will be tested. I think the case that Scott Horton mentioned is probably not the test case they want. I think that's probably something that just came by events. I know that the people at DOD who work on this issue are looking at, very carefully and want the right case so they can test that. So we'll have to wait and see what happens. Certainly subjecting contractors, let alone our military forces, to a judicial process in an area of conflict is a very troubling proposition. Certainly, if it's an area of conflict, the mechanisms for a judicial process are just insufficient to provide the measure of justice we're looking for. So that's often why, in the Status of Forces Agreement, that we do not subject our forces or our contractors to the local country judicial process.
Can I suggest on that subject that it is in your interest, I think, for you to support the constitutionality of Senator Graham's amendment?
I agree with that comment, too. I'll give you a chance to respond in a second, but I just want to say on 2 points you raised, the very good questions. I mean, they're the key questions, in fact. And there's no simple answer to either of these questions. With respect to the constitutionality, it's going to depend an awful lot on what the first test case is that goes up. How is it framed, what are the factual circumstances, and so forth. I believe firmly, and I present this in some depth in the report you'll find outside, that a case that has the appropriate predicates and the right facts will withstand constitutional test in the Supreme Court. I can also think of a lot of cases that wouldn't. I mean, you know, if charges were brought against a contractor for uttering words contemptuous of the commander-in-chief, that's not going to pass. That would violate the First Amendment. That would be pretty obvious. But I think if the charges relate to an area of core concern, they occur in a combat setting in connection with a contingency operation, and particularly if they go to what I call core area of law of armed conflict enforcement. Someone is violating these key rules, which could be a violent crime, it could be an assault or a murder or something of that sort. It seems to me in that area in particular, there's a very solid basis for application of those rules by military legal process that's anchored in the Constitution itself, because the Constitution gives Congress the right to set the parameters of the laws of nations. In 1789, that didn't include a lot of things, but it definitely included this quite clearly. So I think the right case is going to work. The second question you raise is also, I think, one of concern that goes way beyond Iraq and Afghanistan. I think, you know, with the new force configuration, historically we have pursued status of forces agreements that have protected American military personnel, Department of Defense personnel, and others from local criminal law jurisdiction. We've gotten in the last few years far more aggressive about this in reaching out to cover contractors. Now, in a sense, that makes sense because of the change of the force configuration. We rely so much more on contractors, therefore we have a much greater concern for dealing with them. But we've also been much more aggressive with respect to the sort of absolute tone of it. So Order Number 17 is what occurred in Iraq. That was issued the last day by our American proconsul there, and it created immunity from the Iraqi criminal justice system for contractors. And that's created a lot of the problem because it created a vacuum, and then the question was, is American law enforcement stepping in to fill the vacuum that was created? And I think a lot of the problem we have is that, no, the American law enforcement jurisdiction didn't step into that vacuum. And I think the key concern is if we create immunity, we have to follow right behind it with the jurisdiction, criminal law jurisdiction. UCMJ is a critical piece of it, but it's only a piece of it. The most important component of it is going to be action by the Department of Justice. And not to put too fine a point on it, but that is what has been missing, really. If we look at the situation in Iraq, it's been a failure of the Department of Justice to deploy resources to investigate, weed through, and bring prosecutions.
David, let me ask Scott to chime in. Did you want to respond to him further?
Just on CPA Order 17, which is grants immunity, you hear that a lot about that order. That's not a radical departure from our nation's policies in the past when you send troops into a region of conflict. It was revised right near the last days of the CPA and gave it some more granularity, but that immunity existed from long before that.
Follow-up question for Scott Horton. Talking about your test case, Scott. Seems to me, looking at the charge sheet, we have actually a completed preferral of charges, but not referral yet.
We don't have the specification of charges.
Well, it's my understanding that right now we're in the DOJ coordination process on that. If we're dealing with two non-U.S. citizen translators, interpreters, one of whom the accused being a Canadian.
A dual national, as I understand
it. Where is the significant impact upon the military that would justify going under 2A10? And further, isn't there a strong argument that there would in fact be jurisdiction under the Military Extraterritorial Jurisdiction Act under that factual situation, because that type of crime carries at least more than 1 year in confinement? So I'm asking as a matter of law, wouldn't the default be under MEJA, whereas I think Stephen's suggesting also that perhaps it's a question of whether there's the political will to bring a prosecution under MEJA, but as a matter of law, wouldn't the default really be under MEJA?
I think, well, first of all, you asked exactly the same questions we were discussing over breakfast this morning. I think the more we learn about facts from this case, the less it seems suited to be the right test case. It just raises too many issues altogether. And I think, you point to, critical issues. The fact that we're dealing with two non-Americans. So what's the obvious relevance of this to command authority issues, for instance? It's a brawl. It's a simple thing. From what I understand, this got launched by difficult facts. The authorities on this installation were looking for a justification to lock somebody up. The crime was too serious to just let him go, and they certainly didn't want to call the Iraqi Ministry of the Interior and say, pick this guy up. So that led to what happened. Does this really make sense as a test case for a UCMJ? No, I agree. From everything I've seen so far, it doesn't seem to make a lot of sense. And I also agree that if U.S. jurisdiction's being exercised, to me, so far, and we don't really have a completely developed set of facts about this. Maybe you know more than I do, but what I've heard is still pretty rudimentary. But based on what I've heard, it seems it would make much more sense for the Department of Justice to handle this. And the problem with their handling it is may very well be, does it meet this sort of threshold of something we want to bother our resources with? And a big question I don't know a lot about is, what's the severity of the injury that was sustained in this knife brawl? I mean, if it's something really serious, then it's a serious assault, perhaps yes. If it's a superficial wound, it may not make an awful lot of sense. And then we're coming to the most difficult kind of cases to deal with under this system, I think, which are what I call the threshold criminality, minor criminality cases.
I think they may have done that, as you mentioned, just to detain the person, which brings up an issue for the contractors. There's actually a proposed rule out there to require them in their contracts to detain anybody who is believed to have committed an offense. And that really brings up a lot of issues because a contractor does not have any legal authority to detain anybody. And indeed, if you tried to detain them and you were wrong, it could be false imprisonment and you'd be sued. So it's an interesting point of sort of the contractor's role in supporting the law enforcement's detention of personnel.
I just want to add something along my premise, as a professor referred to, that to some extent UCMJ has been turned to because of a failure of MEJA to prosecute. And that has to do with prosecutorial discretion, that has to do with resources, and I think in this particular case, MEJA less efficiently gets their hands on foreign nationals and second country nationals, because there is a question of which U.S. jurisdiction would actually bring charges against them. For a U.S. citizen, and this is to some extent a debate also, it's their home of record, perhaps their jurisdiction. Is that U.S. attorney responsible for bringing charges? Is it the last place they were in the United States? And then for the folks in theater who have to reach back, figure out who that U.S. attorney is, and then convince that U.S. attorney in his political environment and within his resources environment that he should investigate and prosecute this case. And oh, by the way, they have 15 days to do it under the current Memorandum of Agreement. So that's a real problem in terms of some of the legal jurisdictional issues under MEJA. Because UCMJ is so much more effective and you have the authorities right in country to prosecute, it's more efficient and it's better. The final thing I'll say, because I think this is really critical, is there is a reality that we have to be able to deliver justice to criminal actors in theater, whether their actions be on a base or off a base, because it speaks to our credibility with the local populace. And in the kinds of wars that we are in, we have to win hearts and minds. And American arrogance and American credibility is always under attack. And when there are major criminal activities carried out in theater by a U.S. contractor or someone working for a U.S. contractor, whether they're local, U.S. or otherwise, when they escape justice, the impact that has in the media and otherwise in that local community can be massive and can undermine our entire efforts to win in these efforts and can jeopardize and make the safety of our armed forces much more in question because it gets people angry. So there has to be a fix. So far we've turned to UCMJ. I think Scott's made some important constitutional points. Hopefully it stands, because when we don't deliver justice, it really undermines our missions.
Mike Tiger.
My name is Michael Tiger. I'm a teacher and retired lawyer. Really, this is for Mr. Horton, because you're the lawyer that's pursued this. I'd like to get back to the money, because not only do we have armed folks running around, we've got people serving meals and delivering goods and so on, military contractors writ large. So why not use the example of other agencies that are thought to be out of control, such as FAA or FEMA? One, what kind of whistleblower protections are there out there to find out what the problems are at any level? Two, what about the False Claims Act and related key TAM provisions to encourage people to get into this investigative process? That legislation dates back to the Civil War, which is the first time we faced this project in some organized way. And the third question is, with respect to KBR going to the Caymans and so on, where is the Justice Department? Conspiracy to defraud the United States under Section 371 has traditionally been a criminal remedy, even if you don't wind up actually owing the government any money as a result of the manipulations. Indeed, the lead case had to do with precisely what KBR did. So what about that menu to address the problems that you all have been talking about?
Well, I agree. I think, I focused much more narrowly in my report on traditional criminal law accountability, direct enforcement by the Justice Department. I think, these issues that you're raising, are part of a continuum that stretch right beyond it. In fact, the first time I testified before the judiciary hearing, I was addressing my grounds, and we had 3 other witnesses talking about whistleblower protection and key time litigation. And from what I see in those 2 areas, I'm quite troubled by what's going on right now. I mean, I think protecting whistleblowers is and has historically been an important part of maintaining discipline and oversight. And key time goes back to the Civil War, as you point out, has been effective. And this is not something I've studied systematically, but the couple of cases I've looked at where these litigations have been brought, I just have to say I cannot understand the Justice Department. I just cannot understand. I mean, it looks like they're very solid cases, well developed with very good evidence, and the Justice Department seems to view them like they're radioactive material. They don't want to have anything to do with them. So, and I think that fits together with, my comments about criminal law jurisdiction. The big problem consistently in this area has been, Department of Justice and its, failure to really follow through with the exercise of a core law enforcement mandate in an admittedly difficult environment for them. They're not doing it. Now, yesterday, we had, I think for the first time, we had the Department of Justice, a spokesperson appear on Capitol Hill and address the contractor accountability issue through testimony. It was on the Senate side, I think it was the Foreign Relations Committee, dealing again with a KBR rape case. And I was present at the first hearing when Conyers had invited them, in fact, going back 2 weeks earlier, and he got an absolutely offensive brush-off letter from the Department of Justice. I couldn't believe they sent it. And no, so he decided to proceed with the hearings in which there was an empty chair that was marked Department of Justice in front of it for the hearings. My own contacts with Justice Department people, what I heard was, well, there was actually quite a bit of discussion internally about appearing at this hearing and answering, and there was a conclusion that, we really didn't have answers. So it was best just not to show up. Yesterday, we heard for the first time that rape cases, at least, not so much other things, but the rape cases are important to the Justice Department. That was stated. And there are 4 to 6 investigators who are available to look at these sorts of cases. And I know when I looked at this 1 year ago, there were 0 investigators available to look at these sorts of cases. I talked to an FBI agent based in Baghdad who told me how he had raised this and pushed it with Maine Justice and was told, you have a job, stay in your lane, do your job. Your job is, justice support to the Iraqi authorities and keep your nose out of this. So it's it's a political will issue. And yes, I agree that whistleblower protection and key time are an important part of the solution.
I guess a comment on that, as someone who represents government contractors, Scott, I don't know what part of the Department of Justice you're working with in terms of their inactivity in key tam, but let me know. I want to work with that part. The False Claims Act is out there. It's a very real threat. It is something that drives the conduct of contractors to conform with the contract and with law. There are whistleblower protections out there. There need to be. That's important. But that is a very useful tool, and it is active. And if the Department of Justice decides not to proceed or join in that case doesn't go away. The relator who brings that case can continue to prosecute that case and recover, and of course then share in the benefits of any recovery.
I just want to add on the whistleblower side, because this has been a high priority for Senator McCaskill. This is the 2008 National Defense Authorization Act. and we significantly expanded the whistleblower protections for defense contractors. Now, there's still some issues of, do they know what their rights are? What are some of the contract clauses? There's very intimidating, in some contractors, there's very intimidating clauses put into employment contracts that contractors seek to tell their employees that if they disclose any information, that it's grounds for certain punishments within the contract. And so although the law provides you can whistleblow. So we're trying to mediate through or dig through that. But there is, for the first time ever, for a defense contractor employee, a right if they fail to get, within a very specific time limit, relief for whistleblowing activities where there was a reprisal from the Department of Defense and its IG or the Department of State, the ability to go to court with a private right of action, de novo review, and the ability to actually request a jury, to demand a jury, where it is not limited beyond that. So we've made some progress on whistleblowers because they're a critical part of this. And I'll leave it at that.
Jim, right behind you.
I'm Dr. Willie Curtis from the U.S. Naval Academy. I want to direct this to Stephen, but I'd welcome any comments from the rest of the panel. It has to do with, again, the traditional military functions that are being contracted out. And what is your, what do you think the implications are for military professionalism and the military profession itself, because of this third additional mission other than fight and win the nation's wars?
As I said earlier, this is something that I have a personal interest in and have worked on in 3 different congressional offices, in professional military education and the concept of profession and where they are. And as I said earlier, one of my premises and one thing that we have looked hard at, and this applies to all kinds of military advice and conception of war, is that the profession of arms and those in uniform have, over a period of time since Vietnam, narrowed the conception of their profession to a very limited sphere. And in so doing, they divorced themselves from tasks that aren't necessarily not warfare. It was the U.S. Army that built our nation to the west. Someone came in and said, the Army should start wearing blue again, so they remember they did nation building. They built our own nation as expeditionary forces out to the west. And as to, I think the biggest area of the profession, the uniform profession, has struggled with is what role do they have in accounting for the fiscal assets that are part of conducting expeditionary operations. And the military didn't, as far as its command structure, really see or embrace any role in being responsible for the money it spent in conducting an expeditionary operation. When the Senator and I were in Kuwait, a 3-star general who was in command there during a briefing looked at the Senator and said, I don't care if what I need costs $1 billion or $1.5 billion as long as I get it. That is a massive problem in culture. That does not work for the American people, and because of that attitude, because our uniformed leaders divorced from their professional responsibilities to be accountable to the American people for how they use the resources given to them, they have in many ways lost the American people because Americans don't like their money being wasted. And so my view is, and one of the things that Senator McCaskill has really taken up, is pushing the uniformed professionals to re-embrace the importance in their military operations of being good stewards of the resources the American public has given them. And we have done that. And I will just say that to their credit, there is a sea change happening. We are requiring it statutorily that they do some training plans, but MOIs, or the instructions for the war colleges and junior colleges for the new general officers, have all begun to be published. And it will be important. This goes to the points we've been talking about, that in some cases, the problems have not been the contractors. It's a lack of appropriate oversight resources dedicated to them.
Scott? I want to go back a little bit to the question of, core governmental functions, which you're getting to here. And before I said, I didn't like the idea of Congress stating absolute prohibitions. You can't hire security contractors. I think that would be dangerous and unwise. That's not to say that there aren't really serious questions here. and things that should be discussed, and areas where Congress, I think has a legitimate role and voice. And I think there are a couple of things I see out in this expansion of contractors that I find very troubling and very difficult to justify. I'll give you, 2 examples. One of them is on the intelligence side. We're always going to have contractors engaged in intelligence operations. I mean, it's unthinkable that we wouldn't. But when we talk about interrogating detainees and we deploy and use contractors for that process, I'm troubled by that. And I'm particularly troubled when I interview some of these interrogators and they tell me, well, our understanding was that we weren't bound by the military rules of engagement, and therefore we were brought in to do this. That's illegal, actually, and undermines military morale and discipline, as the Department of the Army concluded in the Fay Jones report. That's very troubling, and that may be an area where it may actually be appropriate for Congress to say, no, that's just forbidden. Another area, and with respect to security contractors, I mean, I think here we've got such a spectrum. Imagine that, we have a base in the United States, and there's a decision made to hire a local security company to provide for security for the PX and the movie theater. I mean, who's going to have a problem with that? That makes perfect sense, actually. That may be very, very efficient. But now let's go to Iraq and imagine we have a Marine forward operating base somewhere in Anbar province, and perimeter defense for the base has been contracted out to a security company. That, to me, is nuts. I just don't understand that. I mean, that is really core, and, the Marines in the base should be taking care of the security for the Marines in the base and a war zone. In fact, I talked with a young major out there who described to me one of these situations, and I know there's a lot of anger and irritation about it. I mean, it seemed to me to be a really extreme case where things had gone too far.
Just a quick follow-up on that. I mean, the reason that we are using security contractors is because we don't have enough people for this war in Iraq. So when you talk about forward operating bases and Marines providing perimeter security, I mean, really, if you can replace those guys, and this is what someone has told me, that the numbers are likely to increase of the number of private security contractors we're using, because if you can replace those guys doing perimeter security, you have more people to go into the neighborhoods. And that's, because we're so short on personnel, we're already putting our forces under so much stress. We need those people out there. So these are the decisions that we're making.
Yes, sir, right here on the aisle.
Hi, I'm Tom Egan. I'm a retired Marine, an attorney here in town. And I had a background in special operations in Vietnam. A couple of things. I'm sure that it strikes all of you that we're 5 years into a war that we are now deciding how should we manage that war. The military, and I'm thinking of broadening the UCMJ authority, one of the reasons why the period between Vietnam and the current conflict, the military narrowed its role, is because the military became the go-to guy. If the State Department wouldn't get off their dead butt, DOJ wouldn't do it. Some of your bosses or the predecessors of your current bosses in the House and the Senate, oh heck, they weren't going to pass any legislation. And the military just became the go-to guy because nobody else would do it. As a lawyer, I've got real concerns about this current case coming under the UCMJ. I don't see how that flies at all. I think Department of Justice has got to be told to get moving. I can understand they've got some problems given Attorney General memos that have gone out that some of these contractors could be viewed by Shiite forces in Basra as illegal combatants and maybe be snatched to the Soviet Union or the former Soviet Union, to Russia or Kazakhstan, and treated to Guantanamo Bay, their style. But we need to address these issues as a matter of international law and morality in the country.
My question to you is, the military and any other organization that functions well has to start with who's in charge. The Iraqi war, we have an ambassador out there. In the old days, he would be the head of the country team. Everybody in that country reported to him, including the military commander, as to what we were going to do, how we were going to do it. We don't have unity of command, never have had a unity of command in Iraq. It seems to me you can't really address these issues of who's in charge and telling contractors what to do and how to do it until you know who's in charge. Are we going to continue to stovepipe? Department of Justice sends guys out from the FBI. DOD sends contractors out. State Department, they contract, send folks out. Well, do they report back to the United States or they talk to the guy in country? Last thing I would suggest to you, forget about PSCs. You know, private security contractors make big headlines on the rare occasion when they do something stupid. And PSCs, like Marines, they do things that are stupid. Accidental discharges, get drunk and decide to have a quick draw contest with themselves. But we're talking such an insignificant portion of what's going on in Iraq. You've got, I don't know, 200,000 contractors, subcontractors, and other people running around spending billions of dollars moving stuff, moving gear, or losing money. Seems to me that Senator Jim Webb's former Marine. He doesn't need me to tell him how to run anything. Even the trade school on the Hudson gets it right once in a while. From what you've been talking about today, it seems your focus is on a very minor part of a huge problem, and the first issue is who's in charge.
I'm gonna start with that because I think it dovetails with what we were just talking about in terms of how the military conceives of this and where we need to go down the road, future administrations and future warfare. And that is, to some extent, a professional sea change or shift that commanders recognize they have command responsibility for those contractors. In essence, a contractor delivering food is simply the cooking company someone had in past wars. The challenge is, and we hope our commission gets at this, and we've started, is how do you do that? How do you do that legally? How do you make him part of the command team? And that's difficult. And that's why we have a commission that is going to take 2 years to look at some of it. Although we've started, the fixes are in place, and we've started through the coordinations, whether it be private security contractors or otherwise, to try to get commanders more in charge. That's two things. One, the commander's understanding this is my responsibility, and two, there being a legal and regulatory structure that enables it. The other thing, I just think you're correct to some extent that PSCs are there's a degree of theater and otherwise it gets them more attention. But there is, on the fraud, waste, and abuse level and on the overall numbers, general logistics contracts is where the meat and potatoes work is. And we recognize that, but this is, when I went to Iraq in the invading force with 3rd Infantry Division, we saw active combat a few days in that 30-day run-up to Baghdad, little bits and pieces. When I came home, my mom thought I had been in a firefight every day. Why? Because that's what was on the news. And that is a driving force in some ways. And to some extent, this is the phenomena that applies to private security contractors and why they get so much attention, because they're on the news. But this is why we're trying to get away from some of the partisanship and the theater of Congress and get it out to a commission that can hopefully get away from some of that. We'll see where that goes.
Just in response, I mean, you raised a lot of completely valid points. The reason why you haven't seen legislation coming out of Congress on these judicial issues of MIJA, UCMJ, is, I mean, with armed services, I've talked a lot about what's happened, and there has been progress there. On the judiciary side of things, with UCMJ, MIJA, there are proposals from Congressman Price, who actually represents this district where we're sitting right now, has done the best work on this. And basically what happened is that the armed services side of his bill was accepted in both the House and the Senate, and that's why it was passed. Now, there are elements of it that require the investigations for the DOJ to be more aggressive and transparent about what it's doing, what it's not doing, and making it do more. Within the Senate Judiciary Committee, there's basically a hold on it. One of the senators placed a hold on it at the request of the Department of Justice, and there are negotiations going on between the administration and the Senate, and that's what's stopping it. So, I mean, hopefully these negotiations are going on and something will come out of it, but that's why it stopped. Then secondly, in the Memorandum of Agreement between the Department of State and Department of Justice, which lays out their roles and their coordination, one of the standards that they need to develop that they agreed on is a clear legal basis for holding U.S. government private security contractors accountable under U.S. law. I mean, that's the broad standard. So this is something that they agreed on December 2007. A Memorandum of Understanding is due in July of this year. Hopefully it'll include this, but the Memorandum of Understanding due in July is something required by Congress. And a lot of this, the UCMJ implementation guidance that Gordon England recently released, that was required in 2007 by Congress. And we reminded them again in 2008 that you guys need to release this. So, I mean, like Steve pointed out earlier, unfortunately a lot of these things get caught in that political battle. But there are ongoing efforts. You know, I'm not the one on the committee, so I can't tell you how good they are. But I think there are ongoing efforts to try to sort these things out. And unfortunately, it's just taking undue amount of time.
Okay, I'm going to give you 30 seconds because I've got to become the time police again.
Okay, well, I just want to say I love both the points you make. The first, the macro point, is great because, you know, I grew up in the military family. By the time I graduated from high school, I spent most of my life overseas. And, you know, I remember all the relationships were structured, the legal dynamics of those relationships, Germany, Korea, Japan, for instance, they were really brilliantly worked out. They worked extremely efficiently. And I think when we come forward to what we see right now, it's frankly a mess. It's so murky and so confusing. And I think a lot of that comes from a policy rejection of the models of the past, which is wrong, because I think the prior models were excellent and they work well and they should continue to be followed. Second point is, I think, again, making a point for UCMJ, it's not just there to dispense justice, it's also there to enhance command authority. And that's an important element of the problem we see right now in Iraq and Afghanistan. I think that undermined command authority. And so I think UCMJ is part of the fix for that reason.
So a lot more to discuss, and I'm sorry that we have to stop now, but you have to stop at some time. And I'm sure the panelists who are staying around will be happy to pick up this conversation as we go along informally. But we need to take a break and also a 15-minute break. But first, let's thank the panel for a very interesting study.